Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everybody, and welcome to SpringLaw's monthly webinar on employment law topics. Today, we're going to talk about the nuances and the huge differences between the U.S. and Canadian workplaces. My name is Lisa Stam, the founder and managing partner of SpringLaw, and joining me is my dear friend Terese Connolly, who is from the Chicago law firm Barnes Thornburg, and I will give you a proper introduction shortly. First, I just want to do some quick housekeeping and then we'll move to the introduction slide. So first, if you are one of our clients, you already know that we're an employment and contracts lawyers at our virtual law firm based out of Ontario. Welcome to those of you who are new to our webinar, and a special welcome to any guests that are from the US that are here through Teresa's universe. Please feel free to ask any questions in the chat group. We will try and get to them today. We have heard feedback from our regular attendees, and today is our first one where it's not a half-hour session. We're doing a full hour that will allow us to do questions and just, have more interaction. We're getting some feedback that we're trying to pack too much into 30 minutes. So if you have to go early, just drop off and check out the YouTube channel. Everyone will get a copy of the link after. Feel free to download a copy of our slides. They're in the handout tab in the software. And finally, for more info on our firm, come to springlaw.ca. We have a variety of resources there, including our weekly award-winning blog, a link to our monthly webinar series, and to our monthly newsletter, information about our innovative subscription program and DIY legal products, and then our ebook, So You've Been Fired, for employees recently fired and looking for an alternative to in-person legal services. Okay, I'm excited to introduce our special guest today, Terese Connolly. So Terese is a partner at the Chicago office of Barnes Thornburg. Her practice includes both U.S. national and global labor and employment law work. She spells labor wrong, but we will let her, we'll let that slide for today. She has a deep experience advising multinational corporations on their employment and labor law issues, and she is absolutely my go-to resource if I need an employment lawyer in the most obscure corners of the planet. Terese knows everybody because she does all this global compliance stuff all the time. So she really has an exceptional understanding of how U.S. law intersects with other countries all around the world. So she really is a superstar at this cross-border stuff. Terry and I first worked together at a global law firm about 100 years ago. I was in the Toronto office and she was in the Chicago office of the global firm. And we've collaborated ever since with these cross-border matters for one-stop shopping for our clients. It can just go either way depending on what the client needs. And so I'm really excited to explore the US-Canada comparison today with you, Terese. Thank you for joining us.
Thank you, Lisa. What a very nice introduction. And the last time we spoke was on the other side of the world.
That's true.
We did a panel in Tokyo.
Yeah. So. On social media when it was still like the beginning, and we linked up with someone out of Australia, and it was that's how long ago it was that it was this new thing that we had to all figure out.
Right.
Okay, before we start, of course, it's always important to do a land acknowledgement, and we are virtual, and this is a webinar, but we are all on traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people. And we acknowledge that this territory is now home to many diverse nations, Métis and Inuit. We are lawyers, so of course we have to have a disclaimer. This is all legal information, not legal advice. There are nuances throughout. So here's the extra long disclaimer if you need something to fall asleep to tonight, but this is all legal information today, not legal advice. Okay, let's jump in. So we're going to talk about two things today. We're going to talk about terminations in Canada versus the US. We'll have a little smackdown about what the difference is between those two. And then we're going to go through a laundry list of just nuances that may not be as obvious around the differences between Canadian and employment law in general, and then just ask lots of questions along the way for anyone listening, and we will get to them when we can. Okay, terminations in Canada versus the US workplaces. So I'll start. In Canada, 90% of employment law is governed by provincial or territory law, not by federal law. Terry, how about in the US?
So it used to be, when I started practicing 20 years ago, that employment law was mostly governed by federal law. But we have seen a complete decentralization, and now you will see a lot of state and local laws that are governing employment law, which makes it very difficult for everyone.
Wow. Okay. You know, I actually didn't know that, so I've already learned something. Because I always knew it was like the opposite and all federal, but yeah. Okay, this makes sense. I am seeing a lot more local legislation coming out, and that's starting to really cover most of the workplace issues. Then.
Yes. Yeah. You know, just even from it's a kaleidoscope of laws that multi-state employers and multinational corporations have to abide by. It makes it so difficult, but that's where we come in.
Well, okay, so you're based out of Illinois, so you can certainly speak to any employment and labor law in Illinois. So how does that work, you know, in general with U.S. attorneys? How does that work across the country now?
So as long as your firm has boots on the ground, you can, someone licensed, you can provide advice at the advice and counsel, right? But when it comes to litigating, you have to either be licensed there or be pro hoc vichaed in, which is not something anybody on this call wants to learn about. But my firm can give advice on state and local laws in all 50 states.
Okay. Yeah, in Canada, we have a mobility agreement between the law societies of the different provinces, of the common law provinces. So for any U.S. folks on this webinar, we can advise across the country. There are some agency type rules if you're doing in-person litigation as well, except for Quebec. Quebec is always different because it's a civil law system, and anyone working, you know, licensed to practice law in any of the other provinces or territories should never touch Quebec. It is always different. So if you have employees, you know, if you're a U.S. operation with employees in Ontario and Manitoba, for example, usually a common law lawyer can do both. But if it's Quebec, you'll always need someone from Quebec to advise there. Plus, it's all French. So, you know, you also need someone with the language skills.
Right. I do know that their contracts do need to be dual language, right?
And they have passed more laws about this over the last half year. So it's tightening the rules around that, and the rules around offering up most contracts in French first and documents in French first. So definitely good to pull in a Quebec lawyer for that. And we work daily with someone out of Quebec on these issues all the time. Okay, so the next nuance between, or difference, and this is all leading to why terminations are different between our two countries. In Canada, you have to sign a contract before you actually start the job in order for it to be enforceable. The reason is mere continue employment is not sufficient consideration. So if you're going to introduce a contract after someone started, like by lunchtime on their first day, is after they've started, that contract is now not enforceable, because you have to, unless you give them something like a signing bonus to enter into this contract that almost always is going to contain their legal rights a bit. So they have to get something in exchange for that. So the rule of thumb is have it signed before, ideally a calendar day before, so that we don't all have to fight about whether it was 8:59 a.m. and she started at 9.
That's interesting. We really only have that concept with things like non-competes and restrictive covenants. But in the U.S., as you know, we don't even necessarily have to have an employment contract. You can get an offer letter that is not an employment contract. It says it's not an employment contract. It simply says, you know, at-will employment. and it outlines the basics, their salary, their hire date, whether they're exempt or non-exempt, which we're talking about later in this presentation, and no contract necessary. We're starting to see more, especially with foreign-based companies, starting to see more wanting to do employment contracts. But with higher level employees, that might make some sense. With the lower level employees, it doesn't necessarily make any sense. And there are definitely contractual provisions that need to be included or excluded depending on the employee, the state.
Okay. Then we'll get to the whole at will issue in the next slide. That really is what drives most of this, from what I can tell from the Canadian perspective. The last sort of background issue that's different is that in all contract drafting for employees in the workplace, the courts will always consider the employee the vulnerable party. So if there's any tie, or tie always goes to the employee, not the employer. If there's any ambiguity in the language, it'll always get construed against the person against the entity, the party that drafted it, which is always the employer, right? They have the bargaining power. So in all situations, the employee is considered the vulnerable party, which is that philosophical concept is what drives such a huge difference in the outcome in any litigation.
Right, and we just don't have that. I mean, we actually put in our contracts that it'll say neither the drafting party, both parties have reviewed this agreement, no party shall be given, any weight for having not drafted it. We even contract around that concept.
I think for like super senior executives, and we try and cover that off by saying, having them, and for many contracts, we always have them acknowledge that they've had the opportunity for independent legal counsel. But it's still, if there's any ambiguity, even if there is counsel reviewing it, it gets construed against the party.
It truly is the opposite with us. It's just, that does not happen.
Yeah. Okay, so let's dig into at will. Oh, go ahead if you have more.
I was just going to say, I mean, if there could be a case where the courts could say, hey, this person really didn't have a choice to sign it, and they might take that into consideration, but generally speaking, it is quite the opposite of what you've explained under Canadian law.
I've always assumed it's something like the management rights clause in a collective agreement, where in Canada there's that residual default management rights clause that we can all try and lean on if you're representing the employer. There's no equivalent of that in the employment law context, where I just have the right to run a business, and so I get to make all of these decisions around things. I mean, if it's pure business, maybe, but it's a really big gray area of what ultimately is business versus employee rights.
Right.
Mm-hmm. Okay, terminations in Canada at will. So this is the fundamental difference. We do not have at will in Canada. As soon as any judge or arbitrator or adjudicator sees the phrase at will or smells that we're trying to create an at will contract, they will automatically set the thing aside and substitute in court-made, judge-made law called common law. So what this means is everything, no matter what, is either expressly or impliedly a contract between the parties. So there's always this set of terms. I know I'm going to the bullet number 2, but this is, they're related. In Canada, every employment relationship is a contract. Whether or not you have a piece of paper, the courts will view all the terms and conditions that you've either verbally talked about, or in your handbook, or in an offer letter, or just convention within the workplace, or what the courts think should normally happen. That's all the terms and conditions of employment. And you can't, if you want to break that contract as the employer, you have to give sufficient notice or reasonable notice. And that, I understand, is very different in the States.
Yes, very different. All but one state. They're all at-will states. So if an employee does get a contract, then yes, all the terms have to be expressly included in that contract. Well, or you can make reference to various policies So it, literally the extreme opposite. Now that said, while we have employment at will, which means an employee or employer can terminate the employment relationship with or without notice, with or without cause, there is a huge caveat to that. And that is, as long as it's not for an illegal reason, which is, and by that we mean it's not for a discriminatory reason, or it's not in violation of public policy or some human rights laws. And I think we have a question about the minimum requirement to have candidates sign a contract. It's just 3 or 5 days. Lisa, that's for you.
I think in Canada it's 0. It doesn't matter as long as it's the day before. It has to be before the employee started. So, you know, one could argue that they signed off at 8:30 in the morning and they started at 9. But from an evidence and litigation point of view, it's a huge pain in the neck. I always encourage our clients at least do the calendar day ahead so that you just it's cleaner. So there isn't a minimum of 3 to 5 days. What is maybe where this is coming from is it's good to give that person enough time to review it. If you hand them a contract on the first day at 8:30 and say, look, you don't have to start till 9, so take the next half hour to read this, that will be tricky for you. You know, they don't really have a choice, you know, to review it with a bit of time and clarity. So ideally, you're always giving people a contract at least a few business days in advance so that they can take a look. You know, 1 to 2 weeks is best, but the world moves quickly. I know that's not always possible, but absolutely not the same day is a big thing.
So I'll answer the next question while you read the following question, which I believe is the next question was, which one state is it that's not at will? And that's Montana. Montana has, they have a probationary period, and I don't know the length. I'm going to assume it's 90 days, but I'd have to look it up. If you really need me to, pop it in the question and I'll look it up. During the probationary period, it's at will, but after that, there has to be some notice. I can also look up the notice if you need me to, but the state is Montana.
Montana?
Montana.
Wow, I would not have guessed that. Okay.
Montana. Yes.
Okay. Interesting. All right. So the next question is about, and this is a common practice. You send the offer letter out by email to your candidate, you know, several days, a week or two in advance, but they don't have the equipment to print it up and sign it. So first of all, I would encourage the company to just figure out how to send it to them so they can sign off on their phone. There's enough technology around that in the first place. So you should be able, post-COVID, you know, people should be able to sign off digitally in the first place. If that is not on the top list of priorities to figure out, the other one is exactly how you do have it here, is to have the person, you know, confirm in a sentence, an email, that I've read through it all and I agree to the terms, and then you can have them sign off when they get there. But it confirms that they had a chance to review it all and that they've accepted the job prior to starting. And then it's like housekeeping when they get here to just paper it out. I mean, I still think that's not ideal. I don't love it. There's, you know, if I'm on for the employee, I try and dig holes into that, but it's better than having them sign the day of. Okay, the second bullet I touched on already. Everything is a contract, whether express or implied. This includes handbooks for us. So when I'm Canadianizing a U.S. handbook, there's often at the beginning of the handbook or the employee manual reference that this is not a contract. This is not part of your contract. This is something else. I don't know what that something else is. You have to tell us. But in Canada, I cross that line out, because now the whole thing's going to be a problem. And you want as the employer, you want to be able to enforce the handbook and lean on it for the rules of your workplace.
That's so funny. Yep. So ours, we actually, in order to make it not a contract, we use all this disclaimer language and at-will language, and it has to be in bold and it has to be clear and not hidden. And we say this is not a contract, and we reserve the right to change it at any time with or without notice. So, and meaning change the policies at any time with or without notice. And we even embed in our employment agreements that we have the right to, you must abide by our policies, which we can change at any time, right? So we can still enforce those policies they just don't form part of a contract, mainly because the employer's allowed to change those policies as it sees fit.
See, we have to give notice. If you're going to do a material change of some policy, if you fail to give enough notice, you could have a claim against you for constructively dismissing someone because you're now so adversely, negatively changing the terms of the agreement that the employer is breaking the contract. So usually you'll see in contracts a changes provision for this reason, to cover off, look, if it's a tiny change, we can just do it whenever we want. If it's a bigger change, we will give you some notice.
So interestingly, there are some things that we have found, the courts have found, that do require notice. So for example, if you're going to change your vacation policy, right, midway through, but someone's accrued,
right, okay,
they've accrued but have unused vacation. There are cases that say, look, this is now an accrued right. So you can't just take it away at this point. It's based on state law and how you've drafted your policy, and so.
Right.
I shouldn't say it's a blanket, we can change everything without notice. There are some things that will affect rights that employees have that will require notice.
Okay. Good to know. And good to just talk to a U.S. attorney to figure that out instead of guessing from Canada. It goes both ways. Okay, let's go to the third bullet. The employer must always provide, this is the default legal position in Canada, employers must always provide sufficient notice that they're going to end the employment relationship, that they're going to terminate or fire someone unless there's just cause. And as we all know in Canada, the just cause is incredibly high threshold. You basically need to just steal a whole bunch of money from the company, or steal someone's firstborn. Like it's hard to prove just cause in Canada. So almost always you have to give notice.
Whereas in the States, unless someone has a contract that has a notice provision, or an employer sadly didn't include all that disclaimer language in their handbook, and somehow they can prove that they have some right to a fixed term employment or employment that requires notice, the default then would be that the employer can fire at will, again, subject to our human rights laws.
Okay. In terms of what is sufficient notice, I should also note, especially for any U.S. attendees, sufficient notice in Canada is going to be, there's no rule of thumb, but it's somewhere between 3 to 5 weeks of notice or pay in lieu of notice for every year of service. So if you have someone that's been working with you for 20 years, let's say they're 65 and now you want to fire them, you will likely be on the hook for 2 years of pay or notice in lieu of pay. So you can give them working notice and have them work out the 2 years. It almost always is a disaster, so I tend not to recommend that. But in terms of accruing liabilities as an organization, this is such an expensive moment for employers. And as we see boomers starting slowly to retire, not very quickly, there's an aging workforce. And so there's a lot of longer term employees that are going to get a year or two of entitlement to all this. So really understanding what that entitlement is really important for timing this out. And there's lots of older workers that are waiting for their package, right? They're waiting to be fired because they know that it's going to be a whole bunch. So if you're waiting for your employee in Canada to retire, it's against our human rights codes across the country to force retirement, and I wouldn't even raise the issue because now you're engaging in age discrimination. So this is a live, tricky issue right now that is really expensive because of this default position. Notice is a lot.
I'm going to ask a question that I know anyone from the U.S. wants to know. 2 things. Can you give them part notice and part pay in lieu?
Yes, you can. You can combine. So that's the employer. That is the one thing the employer can pick is you can either do it all as either a lump sum. Let's say you owe someone a year. You can either pay them a lump sum of their salary right away, or you can do it as salary continuance for a year, just keep them on payroll for a year and they don't work. Or you do working notice where you have them continue to work for that year while they're on payroll. Again, that usually is a disaster. Most people don't work very hard if they've just been fired. And then, or you can do a combination. Maybe you need them to transition the role for 3 months, and then you give them a lump sum for the other 9 months, sorry, or salary continuance for the rest. So there is some combinations there that you can work through.
And is there a maximum?
Notice? No, and people go above 2 years sometimes. Yeah, but 2 years is sort of, there's a handful of cases now that go above 2 years to 26, 28 months, 30 months. They're absolutely outliers and exceptional reasons. Usually for most employees, it caps out at 2 years.
Okay. All right.
Okay. I think there was another question. Okay, well, it's a reference check question. Let's keep going through this, and we'll probably get to that actually on this page. It is it fine to give positive references? Sorry, this isn't a question. This is a statement. I'm telling you, it's fine to give positive references to people when you've let them go. And this is something that I struggle with every day when the Canadian operation has a U.S. parent. There's law in Canada that you need to fire nicely. It's embedded into our system. It's not just a stereotype. You giving a positive reference there's two good reasons. One, it's a good faith gesture. You be truthful about it. Maybe they were not your rock star, but there are some truthful things that you can say about them. Like, did they show up on time every day, even though they weren't your rock star? But giving references is important for good faith, so you don't have good faith damages launched against you as the employer. The second reason is of this concept of mitigation in Canada. So employees, let's say you have one of these employees that have been there forever and they're an older worker and they're entitled to 2 years. That's their common law amount. That's what the court would give to them, assuming their contract doesn't say something else. So they get their 2 years. If they find a job after 1 year of looking, they've now mitigated their losses, and the employer only owes them the first year. So salary continuance can allow, and assuming that you've put in mitigation in the settlement, it does allow the employer to turn off the tap if this is someone who has mitigated. Often it's a lump sum, and it's not worth it to fight over a few extra weeks if they end up getting that. But if you give them references and you sign them up for coaching and you help them find a new job, it's a self-serving benefit to help mitigate the losses and turn the tap off sooner. So there's all kinds of, and the idea of being sued by a future employer for misrepresenting this person, I mean, because everybody gives glowing references. We just know that, right? Everyone's going to give nice glowing references. It's not a thing to sue a past employer for misrepresentation on a reference letter. So we're not worried about litigation on this issue.
Yeah, and in the US, I don't see that as much anymore, but we do see the former employee suing for defamation or something, because so really what we tell all of our employers is just make it a policy to merely provide dates of employment and title. If someone is leaving without issue, then you can go ahead there and people can do letters of reference. That said, usually requires them to go to HR and get approval to write that letter of reference.
Yeah, and that the date, the letters with just like the letters of employment where it's just a start date and end date, it often, and maybe this is changing as we get more familiar with the U.S. practice, it's construed in some circumstances, oh, I guess this wasn't a very good worker. They were unable to get a proper reference letter. They've got this thing that's not a real reference letter. There's nothing, it's so neutral that it's signaling to me, the new HR person in the new company, that this wasn't a very good worker. So it can sometimes work against candidates. That's the problem we're facing. And so if in doubt, if you can just write, Jimmy showed up regularly and was a loyal employee. Like, that's something. That's better than Jimmy started on X date and ended X date, and this was his title when he ended.
Right. A lot of the more not robust, but positive letters of reference can be negotiated too.
Yep.
Yeah. So.
Yep.
And
you know what?
Agreement.
Okay. Yeah. Okay. Perfect. So part of the terms. Fair. That's fair. See, we tend to, or I certainly recommend, don't, well, there's our legislation that requires the statutory minimums everyone has to get. And then there's all the stuff on top of that. And I recommend putting the reference letter and just give the reference letter if you can, again, for this mitigation reason. It can gut an employee's case, right? There's a good practical reason on that front to do it. The other piece around this, if I'm on for an executive, I will encourage them to draft their own reference letter and then submit that as a request. That way they can really, craft what will be helpful to them for the job that they want to get next.
I think that is a brilliant suggestion if you're repping the employee, because absolutely what you're going to get if it's a negative situation and that's what you're negotiating, you're just going to get slightly more than title and dates of employment. You might get, attendance record. So yeah, agreed.
Well, and even if people are not unwilling to say something positive, people stop wanting to invest any time in an ex-employee. So it's more of a practical reason as well. Just, craft what you need.
Right.
Okay. Termination packages must make the employee whole. So it's not just the salary. So let's say someone has been there, for a few years and all the factors lean towards a 6-month package. They have to get 6 months of everything, not just their salary, but what would they have earned over those 6 months but for the termination. So the courts always talk about you have to make the employee whole. So any bonuses they would have earned, which is subjective and tricky sometimes, any commissions, anything that's a certain kind of earning, like pension benefits, for sure, any of that. If there was a scheduled annual salary increase, often that's argued about, that they would have gotten the annual salary increase but for this termination, and so the last part of the package should be more money. So making them whole, it's not just the salary.
Yeah, so any, unless it's a contractual severance package that requires the signature of a release and exchange, most termination packages are really just, as the slide says, a creature of negotiation. And why are we entering into this package? It's usually a settlement for some dispute or to settle a case, really. So it could be pre-litigation settlement. It could be during the litigation settlement, and it's 100% discretionary, again, unless there's a contractual provision that provides for some sort of severance.
Okay, so that is a bit different. I'm going to go to some questions on this reference piece. I forgot to go back to it. So when doing reference checks prior as part of the hiring process and the candidate has accepted the employment agreement, that is subject to satisfactory references and background check. If the references are inconsistent, can we contact the companies that they have noted in the resume without their knowledge? So I would say employers are always allowed to do proper reference checks. So for sure, go ahead on everyone's social media. Don't hack into someone's system or pretext. But if you want to Google a candidate, for example, go ahead. In the course of Googling, you'll run across their LinkedIn and see who their past employers are. And if you want to call up that employer, there's no reason not to. If there's a background check issue and let's say a criminal charge arises, that is a really complex issue. Our human rights codes have some rules around that. You can't discriminate someone on the basis of a record for which a pardon has been granted. So so if someone's been charged but not convicted, that's a weird gray area. If it's a traffic ticket, who cares? But if it's a drinking and driving charge, that's different. If you are a bus driver company or a taxi company, you can do a little more around driving abstracts. So I know this is a very lawyerly answer, but it does depend on the job itself and what is reasonable that you need, because in Canada, in general, background checks are pretty contained because of privacy law rights.
And that is true in the US too. Probably not as contained, but absolutely there needs to be consent and notice. And so assuming consent, assuming notice, assuming that, but contacting without their knowledge is usually not acceptable at all. Yeah. Especially, I mean, you don't know if they've given notice or the employer knows interviewing.
Yeah, and I would say that's a good example of whether you're allowed to, should you, right? I mean, it puts a relationship on the bad first step, I would say, of just trust.
Right.
And if they say no, then that's a bit of a red flag, right? So you can, but
well, unless they say, I don't want my current employer to know, and this person's at my current employer. So.
Yeah, and that's fair, right? Because if they don't get the job, they still need to stay there. So I do think people should respect that practical reality and not draw conclusions from that.
Right.
Okay, benefits do not drive most terminations in Canada. That's me putting a bit of a bold statement on there. There are definitely cases where benefits are a big deal, but because we have a public healthcare system, there's always that backup. You can, and for our U.S. friends, just as a reminder, in Canada, you can just go to the hospital and get surgery for free. It's entirely publicly funded. It's why our taxes are bananas, but it for a good cause, I figure. And so termination packages, there are group benefits that are offered in Canada and pension plans, but the benefits are more dentistry is not covered and eye examinations, eye stuff is not covered. And the rest is kind of like perks, like your chiropractor or massage benefits or, orthotics, there's sort of perks, but the core basis of benefits are already covered in our public health care system. So it tends not to be any sort of driver of the process.
For us, it is, it can play a part, or for example, for people who are single or whose spouse does not work and they can't get on their benefits, then it does. That's when you usually see people try to get, we have something called COBRA, which extends your benefits, but usually you have to pay. The employee has to pay both the employer and the employee portions, and it's pretty expensive. So, but you will see that be part of the negotiation process for those who would otherwise not have insurance.
Mm-hmm. Okay. I've also seen that in contract negotiations up front, not just in terminations. And I can think of one example a few years ago of someone who, this was her first major job in Canada, and she was just spending so much time on the benefits section. And it just took me a while to realize why. It's just that, she had her PR here, she was marrying someone here, so she had moved up to Toronto for love and was going to be fine. And it took me a while to realize, it's because you need to be careful in your contract negotiation up front. But here you definitely talk about it, but it's not the end of the world.
Right, that's true, yes.
Yeah. Jury trials. There are no jury trials for employment law cases in Canada. And I think, this is just my subjective opinion and a bit of a soapbox, I think this is partly why employment law moves in a pretty incremental stage. Our damages are way different than the United States. It's just so much less because we've just got, it's all judge only made law slowly at a time. So when I have clients coming to me reading, telling me about headlines they've seen of someone getting, billions of dollars, I'm like, that doesn't happen here. It just doesn't happen here. You read a US article. Maybe not billions, but more than
so we will have jury trials. People can waive those, but what a lot of employers do is require arbitration, and they'll do mutual arbitration. There's a lot arbitration, and when it's allowed and not allowed is super, it's like a moving needle. You will never, it's all over the place. But in general, employers will try to get arbitration if they can, because it's not public, and that's huge for employers. So we do have some state laws that have said, and federal law that have said, in certain cases with sexual harassment, you can't require arbitration if the person wants it to be. And I don't even want to get into arbitration, because I'll just tell you, we could do a whole series of webinars on arbitration. Yeah. But know that you can have jury trials, but a lot of employers also do require arbitration, which is going to be 100, which will not be public.
That's really interesting because I since we both started practicing, I've seen more arbitration provisions, in agreements. But when I'm on for the employee, I don't love them because now you're having to pay for half of the process, whereas otherwise a judge is free in Canada. And so, and there's a system, there's accountability in the system. There's, we have small claims or simplified procedure options if it's a smaller claim. Whereas arbitration, I feel like the parties can sort of, rag the puck a bit more, and then you have to pay for someone to adjudicate it all. So this makes sense to me that this is an influence coming up to not have these juries in, because juries are irrelevant for us in the employment law context.
Okay. Yeah. Yes, definitely seeing more arbitration clauses. And I do think that employers like them. Employees might want them because it's faster. It just depends. In California, for example, the employer has to pay. So it's one of the ways you can get it enforced as being mutual. Employer has to pay. There's a whole bunch of provisions that you have to make sure that you abide by in order for it to even be an enforceable to enforce arbitration in the first place. And
we do have arbitration legislation for sure. In Ontario here we have the Arbitrations Act, but it doesn't speak to the employer having to pay anything or pay all the bill. And usually, like if you do mediation, quite often the employer will pay the full bill to try and level the playing field. But
do your arbitration organizations? So we have JAMS and we have AAA. They have their own set of rules.
Yeah.
Employment rules.
And we have different arbitration chambers and organizations. Yeah, the same thing. So I'm probably being a little too cynical about being able to rag the puck a lot. I just, you do have an adjudicator that you've now retained that will help case manage the litigation. And I mean, there is the upside that it can move a lot faster than courts. Like our courts are still so backlogged from COVID. So it's, that is a slow process one way or the other.
That is true. That is true. It does move the process along typically faster. But what we've found, though, is it isn't necessarily less expensive.
Right. So. Yeah, that I agree with. The tribunal, can you go through a tribunal? Actually, that's a good question. That might be a difference. So for employment law in Canada, it's always the courts or an arbitrator, private arbitration. But employment law is done through the courts. If it's unionized stuff, if you're with a union, then that would be an arbitrator, and that has to go through arbitration first. It cannot go to the court second. The courts will always kick it back because of this Weber case from a whole bunch of years ago from the Supreme Court of Canada. So it always, labor arbitrations always are with a private arbitrator. Employment law is always with the courts. And then you have human rights. So if it's a human rights matter, that can go through our human rights tribunals that we have across the different provinces and territories. If you want to attach certain employment law type damages, then you may want to go to the courts and tack on your human rights matter there on top of your employment law matters, because the tribunal for our human rights has a more contained mandate. It's it's subject to its own pretty narrow range of things that it can do. Okay, I'm seeing the time and I'm getting repeated reminders now from Jess and Mandeep behind the scenes. So let's move on to the next one. Okay, terminating is very different. Let's look at some of the other nuances and we can zip through some of these. So this exempt and non-exempt. I have this conversation with US people all the time. It doesn't matter in Canada. If you're doing how you pay someone, whether it's hourly or salaried, doesn't matter. It does not dictate whether or not someone is going to be entitled to, I can't think of any employment law that it's a payroll logistic for sure, but and so it might dictate how you decide vacation, how but it does not decide whether or not the person is allowed overtime or not.
So in the US, we have two tests that decide whether someone's allowed overtime. It's their salary basis test and then the duties test. So you're looking at both of those things. And there's federal law and then there's state law. So some states will follow federal law, but others have more employee-friendly laws on the books. So non-exempt essentially means that if you are paid under the salary threshold and your job duties don't meet certain tests, whether it's the administrative exemption, whether it's the executive exemption, the highly paid professional exemption, if you don't meet any of those exemptions, then you are going to be allowed overtime for anything in most states over 40 hours a week. Some states also have a daily overtime. And then there are all kinds of other rights like meals and rest breaks and whatnot. So it does make a huge difference in the US. And it's one of the that most people don't. When I say, well, is it an exempt or non-exempt, I usually do have to explain, and I have to look at the role, and I have to look at what they're being paid and how they're being paid. So
interesting. I mean, so we do use the words exempt and not exempt for overtime. So as an example, but it doesn't, that exempt or not exempt doesn't turn on hourly or salaried at all. It's just, are you a manager? Are you an IT professional in charge of the architecture of your company's IT? Or are you one of the licensed professionals? Lawyers are not entitled to overtime, for example, but I could pay my lawyers hourly or salaried, and it would not have any impact whatsoever on whether or not they're entitled to overtime. So we use the word exempt or not exempt, but in a very different context. It's only for whether or not they're exempt or not exempt to overtime.
So ours isn't necessarily that it's salary or hourly. That doesn't tell you whether you're exempt or non-exempt, right? It's whether you meet the salary basis requirements. So I think at the federal level, I just pulled it up because it did change, not less than $684 per week. And there's more around that analysis, but just generally speaking. Okay. So you can be non-exempt and be salaried non-exempt. It's more rare, but it does happen. So again, that's that salary basis test. And then if you meet that, you also have to have what you have in Canada, which is very similar, which is the duties have to fall into one of our exemptions.
Okay, so that it's the second test that would be very similar. The first one is different.
Okay. First one's different.
Okay, very good to know. So in terms of overtime, our legislation in the different provinces and territories will typically say, you know, the employee is entitled to overtime unless they're exempt, they're a manager or something like that. So they're entitled to overtime if they work it, period. And so what becomes a bit of a dispute is, well, I didn't authorize you or give you permission to or require you to work overtime, and now you have. If they work the overtime, we have to pay it under all of our employment standards. You just have to pay that overtime. And so then you need to, for the next time, start including rules or, you know, contract provisions that you are not allowed to work overtime unless authorized ahead of time.
So even if you have that rule, you're not allowed unless authorized in advance. You still have to pay if they work it. But you can discipline them up to and including termination.
Isn't that weird that you have to discipline people for working extra? I always find it like a bit of a weird disconnect, but it's like just such an employment law thing that we have to do.
Maybe we're saving the workaholics. I don't know.
Yeah, there you go. Exactly. Yeah, perhaps. Or the slackers who didn't work until lunchtime and now are working until 8 at night. I'm sure that's part of it as well. But over the last decade or two, we have had a bunch of class actions around defining who is entitled to overtime, and that, you know, it's a nice common issue to sink your teeth in. So we've had a few class actions, you know, at some of our big consulting firms, accounting firms, banks.
I would have to say we've had more than a few. The land of litigation.
Yeah, fair enough.
I just love the sue.
Okay, let's talk about parental leaves, which are really similar between our countries. You know, in Canada, you can be gone for 18 months. The federal government will pay you a bunch of money during that. Many companies top up. You're entitled to your job when you come back. or a similar job. It may not be the identical one. There's lots of protection around it. You have to continue benefits during the whole time if the employee wants to continue their copay. I'm sure it's exactly the same in the States.
Right. Yes. This is the thing that makes everybody want to move out of the United States into our northern neighbor, right? Ours, that should say FMLA. I'm sure. I actually remember when I was doing the whatever.
That's our typo. Sorry, Teresa.
Spell check. No, that was I remember seeing it and pressing accept. Whatever. Anyway, the point is, it's Federal Family Medical Leave Act, and there is the federal law, which requires for private employer employees unpaid leave for up to 12 weeks. And then the federal employees actually do have some paid leave. But in any event, the vast majority of the people in the United States have zero pay, but they'll get some time off and it's protected leave. Some states have been coming around to and providing some paid leave. Whether it's sick leave or some are paying some family leave. It's not much and it's not many states, but we're coming around, and that we're starting to see that change. And hopefully, if more and more states do come around, maybe the federal law will catch up. We'll see. There's even some states, I think it's New York and California, that do have something similar to what you have, where everyone pays into this bucket, and then the state pays a portion of, and then employers can, if they want, pay on top of that. A lot of employers, depending on the job, depending on the industry, they will pay the leave, but they don't have to pay it. So there are a lot of our workers who are just out of luck, sadly.
Well, and we're starting to slowly see the uptake on, women take the first few months. So the first part of these leaves are the pregnancy leave. And then the rest can be shared between the parents. And so whether it's same sex, not same sex, like it just whoever are the parents of the kid. And we're starting to see more and more men take these leaves. And I think as a feminist, I'm so delighted about that, because then that perceived adverse impact, or perceived pain in the neck of hiring a woman, it will start to fall away, hopefully, as more men who are going to want to spend time with their kids. I just think it's such a wonderful development that will really start to equalize the impact one way or the other.
I completely agree with you. There are studies that show that if in the first I think it's the first few months, if a man stays home and helps and is involved in the care, they will be more involved later on.
I mean, just look at Scandinavia and all the happiness studies, right? And the really fantastic leaves that they have there. Just to be clear, we do so. The rules around the entitlement to leaves, parental leaves, pregnancy parental leaves, are at the federal and territorial level for those employees. The benefit, the money benefits, is coming from the federal government. So on everyone's payroll, anyone who earns regular income, they pay their income tax, but they also have deducted from every dollar they earn a bit that goes to our Canada Pension Plan, or CPP, and also our employment insurance regime. And so it's a copay. The employer pays, I think it's 60%, and the employee pays 40%. And I might be wrong on that percentage, but it is a copay. So we are all contributing to our EI plan. And you had to have worked a certain number of hours the year before and thus contributed into it in order to qualify. It's a pretty low number. It's like 500 or 600 hours, but it's depending on where you live in the country. But we do contribute into it. And so if you're fired without cause, and you can access termination benefits, and then also these parental leaves. There's a bunch of other leaves, but just related to this topic, we do contribute to it. So it sounds similar to the New York regime that you're talking about.
Yeah, excellent.
Okay, we're on into the final 6 minutes here. So we have 2 more nuances. So we'll just stay fairly high level. Privacy rights in Canada. The Supreme Court of Canada back in 2012 started having a couple of cases come out that really explored privacy in the workplace. So there's one case that speaks to you can minimize employee expectations of privacy, but you can never diminish it altogether. There's always going to be this residual right of employees to have some level of privacy in the workplace. The Ontario Court of Appeal also put out a case in around the same time that spoke to privacy rights as between employees. So in that case, one employee was intruding into the privacy of another one, and there's now a remedy of employee to employee around this. The ripple effect that we see the most on this is drug testing, background checks, workplace recording. All of those are really tricky to do, and especially if you're in a unionized workplace, because every collective agreement will have privacy rights implied into it, and often the union will have negotiated in specific privacy rights that keep knocking down drug testing rights, for example. So if in doubt, there is this employee privacy concept in Canada.
And that's interesting. We do have that very similar privacy rate when it comes to drug testing, background checks, and recording in the workplace. Usually it's recording audio or private, like a locker room or whatnot. But I definitely believe that worldwide, our expectations of privacy are not nearly what they are outside the US. We even put in our handbooks that no one using the systems should, our systems should have any expectation of privacy in order to kill that, so that so the employer can go look at anything you're sending to and from your work email or computer systems or your work phone, for example. All of those expectations of privacy are typically not completely obliterated, but darn close.
Diminished in Canada. They're not eliminated. Yeah.
We also are seeing, so with respect to just privacy laws, data privacy laws, we are starting to see some pickup in the US that we haven't before. So California is the one that I think that got us kicked off, because California is our nice employee-friendly state, and they kick us off in that direction. Thank you, California. So California's CPRA, the California Privacy Rights Act, that went into effect in January. Virginia instituted one that went into effect in January, and then Colorado, Connecticut, and Utah will be coming up later this year. And there are more coming up on the books, but they are, they differ from traditional data protection laws in that we kind of confer a set of rights to individuals, and such as a right to copy of personal data held by businesses and the right to have it corrected or deleted. But the California Consumer Privacy Act, that one went into effect of June of 2018, and its really model was the GDPR. So in any event, we are seeing that landscape in the United States change.
Yeah, because I've always told clients, look at these cross-border situations. We're more like Europe than the U.S. when you're looking at your privacy, but I got to start modifying that advice as we go along. Wow. Okay, we've already talked about our public health care, so why don't I skip to the end? We've, if there's any other last-minute questions that anyone wants to pull in, we've tried to address them as we go along the way. I see there's still a good number of people on, so if you do have any questions, just let us know. In the meanwhile, I will start wrapping up so that we can all end on time today. First of all, Terese, thank you for joining us today. I'm very grateful that you were able to, I know you flew in last night from advising clients in Europe, so you're probably a wee bit jet lagged, and I'm grateful that you're even here this morning, so thank you very much.
Thank you for having me. It's always fun doing these.
Awesome. Well, and I love bantering back and forth about the differences. I feel like the differences are getting less stark, actually. So we should do this webinar in 10 years and do another comparison and see what the differences are. Yeah, sorry. It's post-COVID, so I'm allowed to say that I have a dog, and my dog is barking, so sorry about that, everybody. Okay, so let's conclude. I'm not seeing any other questions come in. We're certainly around. Here is Teresa's email address and contact information if you have, for all of our Canadian attendees that have some U.S. questions. You can either go through us and we'll introduce you, and we just make it one-stop shopping on our invoices, so just let us know. But that concludes our webinar for today. We take a break during the summer because in Canada, we only have 2 nice months of weather, so we're not doing any webinars this summer. For any Americans on the line from the South, they're wondering why don't we work in the summer. We will resume in our next webinars on September 20. Please visit our website to stay in the loop, and if you're on our newsletter, you will get some info about that anyways. Come on to our website if you have any more questions or would like to learn more. Feel free to join us on social. We do all the things: Facebook, Twitter, LinkedIn, Instagram. I've been experimenting with TikTok, and then our YouTube channel. So this webinar itself will be uploaded to YouTube if you want to listen to it again. And thank you for joining us. Teresa, any final words from you?
No, this was fun. I like it. I think we should get back in 2 years, not 10, because things are changing in the U.S. We are, as I told all the people in both Germany and in England, I was in London and Frankfurt doing these presentations. We are following you all more. We're just taking a lot longer to get there. We're moving slowly, but I think it's going to.
Okay, so our webinar in June of 2025, Teresa will be joining us, and we will do this all again. Awesome.
All right, thanks all. Thank you.
You have a great day, everybody.